Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I have another attorney at Hoglund Law Offices, Matt Garner. Today I wanted to informally talk to him about what clients worry about when it comes to a Social Security hearing. Now, Matt, you do quite a lot of hearings a year. How many might you have done just this year, you think?
Up until July, I've done over 300 hearings.
So usually about every day you're in a hearing room?
Yeah, I do about 10 to 15 a week.
And in there you're talking to a lot of different judges?
Yes.
Are the judges different?
Judges are all different.
Okay, but it's the same law, and there are different medical problems for Social Security cases, though, right? So you have judges that are different in how they look at the same information?
Definitely.
Okay, so when you're talking to clients, I take it, as in my experience, they're somewhat nervous going into a hearing. What sorts of things do you tell them?
Well, for one, I do prep a client differently for each judge, and I think that my experience when you have an attorney can really help with the different questions the judge asks. But every judge is the same in the fact that they are not adversarial, they are not against the client, they're not going to yell at the client. So I tell them it's not like a Judge TV show where you have a Judge Judy who's yelling at you. You're not going to have an attorney cross-examining you. It's a lot more of a friendly, informal hearing. I tell them mostly it's more of a conversation about what's going on with you.
So what's important, that they say exactly the right thing, or that they understand what the point of the hearing is? What do you think?
I think the most important thing is that they get across to the judge how they're feeling. And the judge wants to know that. They're not out there cross-examining the client. They're not out there going against them. What I tell the clients is, if you leave the hearing and you let the judge know what's going on, that's the most important thing. And I will cater everything to a different judge with different questions, because I know judges pick up on more specific things. But in the end, I think it's if you let the judge know what's going on, that's the most important thing.
Now, there's a judge, a federal judge at the hearing room. There's an assistant that helps the judge in this private conference room. But there can be a vocational expert, occasionally medical expert. But what do you tell clients about the experts at hearings?
I usually tell them that the medical expert might say something against them, but I have a chance to cross-examine them. I tell them the vocational expert's going to list jobs. That's what happens. They list jobs that might be out there. The judge can believe them or not about different jobs. Ultimately, though, I have a chance to cross-examine them, and ultimately it comes down to you letting the judge know whether you can work or not.
What would you say about people that aren't sure about hiring an attorney before they go at least into the Social Security hearing?
I know how to prep clients for the judges. I know how to cross-examine the experts. Most people who don't know that don't know how to cross-examine experts. They don't know how to deal with something like that. It is important to have someone guide you through the steps to let you know what's going on and to kind of be a reassuring side to you when you're dealing with the whole process. Again, you'll have times when we have looked through the records, we know the records in and out, and the clients usually don't know that. The judges don't have time to look through all the records, the experts don't have time to look through all the records, but we do look through the records. So we definitely have a step up where we are more informed about the client than the judge or experts are for the most part. And that's the time when we can really bring out the record and show that the medical records prove that someone can't work. You come to a hearing, it's hard for a client to read, understand, know the difference in the medical records. The judges don't see it, the experts don't see it. We can bring up stuff, and it happens time and time again where I will bring up a medical record where the judge or the expert goes, "Oh yeah, I didn't see that," and then it totally sways their opinion on a case. And I feel sorry for people who are not sorry, I feel bad, not represented. You're not going to have that expertise, a lawyer bringing that out. And that could cost you monthly payments and possibly, the ability to house or feed yourself.
You might have to start over.
Start over, yeah, and that's the worst part. The worst part is when I get clients who lost that hearing and need representation for starting over.
And I'm guessing that if we look at the situation and think perhaps if the information was presented the right way, it might have turned out differently, but it's too late then usually.
Right, and you lose at a hearing and you're starting from a step down. And we take clients who lost at hearings because we think they have good cases. It's just unfortunate they go through that process.
If only they called earlier.
Yeah.
Thank you very much, Matt, for talking with us today. If you have more questions about Hoglund Law Offices, you can feel free to call the number below on our screen. You can also go to hoglundlaw.com. We have information on there about the law, also about medical information that relates to Social Security, and finally, we have information about us, including Matt. Thank you very much.